I strongly support Representative Fitzgerald's Separation of Powers Restoration Act, and I'm proud to be a co-sponsor of this important legislation. Judicial deference is a harmful doctrine placing the American people at a distinct disadvantage in court when going up against what has become an all too powerful administrative state. Separation of powers is the foundation of our Constitution, guaranteeing our right to a Republican form of governance while checking the tyranny of mandates by fiat. The modern administrative state stands in stark contrast to this model, and the creation of the deference doctrines has only further upended this separation of powers, pursuant to which federal agencies oftentimes not only diminish, but sometimes outright ignore congressional intent, with deference then allowing them to also infringe on judicial review. So I want to thank Mr. Fitzgerald for offering this bill to level the playing field by requiring courts to use de novo review of all relevant questions of law and to discontinue our judicial branch's willingness to allow unelected bureaucrats to do their jobs. I also believe it is important to clarify the intent of this legislation. Providing for de novo review of all relevant questions of law, including the interpretation of constitutional and statutory provisions and rules made by agencies, as the bill outlines, is not intended to be a limiting statement. It cannot be a limiting statement if we are to fulfill our goal of reining in the administrative state. This means addressing the array of issues that may arise under the Administrative Procedure Act. One such issue is the question of agency guidance, described as informal, non-legislative rules or documents which constitute an agency statement of general applicability intended to have future effect on the behavior of regulated parties that set forth a policy on a statutory, regulatory, or technical issue, or an interpretation of a statute or regulation. These forms of guidance don't follow the notice and comment requirements of the APA and don't have the force of law. Yet we have seen a growing trend whereby administrative agencies attempt to use guidance to make new law while at the same time avoiding the APA process, and then argue that such guidance is not reviewable by the courts because it does not constitute final agency action. They compound the problem by then seeking to have the courts defer to their opinions in that regard. Because guidance is, by definition, intended to guide something related to a statute or regulation, it must also be subject to de novo review under this bill's language. It is for this reason that this bill is not limited in scope. It follows from the text of the bill, and it is the intent behind the bill that judicial de novo review of all relevant questions of law includes questions of law surrounding agency guidance. If we are to carry out the mission the American people tasked us with when they gave us the majority, which includes reining in the abusive federal agencies, we must include the growing area of abuse as represented by agency guidance. The fact is that deference unfairly pits the administrative state against the American people. It further undermines our rights by distorting the intent of the laws as written by our elected representatives. It also undermines the very purpose of judicial review by creating systemic judicial bias in favor of administrative agencies, which at this point in time have become far too powerful and far too dictatorial in their actions. Correcting this harmful construct of deference to agencies, including the guidance that they issue, is one of the most important tasks we can take on, and this is an important piece of legislation. I am proud to support this bill and urge all of my colleagues to do so as well. I also request unanimous consent to introduce an article published in the Wall Street Journal on May 9th, 2023, entitled "The Deep State is All Too Real," written by former DOI Secretary David Bernhardt. Thank you, Mr. Chairman, and I yield back. Having been a practitioner for over 30 years and having many cases against federal agencies, I can assure you that the courts have moved well beyond deferring to regulatory agencies in ambiguous situations. I'm going to read some of the language from the Rapinos decision that was issued by the United States Supreme Court in 2006 as a way to emphasize this point. According to the decision in that case, the burden of federal regulation on those who would deposit fill material in locations that are denominated as navigable waters of the United States is not trivial. In deciding whether to grant or deny a permit, the U.S. Army Corps of Engineers exercises the discretion of an enlightened despot, relying on such factors as economics, the aesthetics, recreation, and in general, the needs and welfare of the people. The average applicant for an individual permit spends 788 days and $271,596 in completing the process, and the average applicant for nationwide permits spends 313 days and $28,915 in seeking permits. The enforcement proceedings against Mr. Rapinos are a small part of the immense expansion of federal regulation of land use that has occurred under the Clean Water Act without any change in the governing statute. I will repeat that, without any change in the governing statute. During the past 5 presidential administrations, in the last 3 decades, the Corps and the EPA have interpreted their jurisdiction over the navigable waters of the United States to cover 270 to 300 million acres of swampy lands in the United States, including half of Alaska and an area the size of California in the lower 48 states. And that was just the beginning. The Corps has also asserted jurisdiction over virtually any parcel of land containing a channel or conduit, whether man-made or natural, broad or narrow, permitted or ephemeral, through which rainwater or drainage may occasionally or intermittently flow. On this view, the federally regulated navigable waters of the United States include storm drains, roadside ditches, ripples of sand in the desert that may contain water once a year, and lands that are covered by floodwaters once every 100 years. Because they include the land containing storm sewers and desert washes, the statutory navigable waters of the United States engulf entire cities and immense arid wastelands. In fact, the entire land area of the United States lies in some drainage basin, and an endless network of visible channels furrows the entire surface, containing water ephemerally wherever the rain falls. Any plot of land containing such a channel may potentially be regulated as a, quote, navigable water of the United States. Why do I read that? Because courts have been deferring to that nonsense now for decades in terms of the immense expansion of the EPA and Corps of Engineers authority over what is defined in the Act as a navigable water of the United States. How have they been able to do that? Because the courts have been abdicating their responsibilities of deciding questions of law de novo, and they have allowed the agencies to make those decisions. That's why this act is so important, the Separation of Powers Restoration Act of 2023. I can understand what my colleague is saying about the concerns of courts making the decisions, but we're not talking about activist judges actually doing their job if they are reviewing statutory and regulatory documents, laws de novo. It is when they defer to the agencies that they fail to do their jobs. Having been someone who has tried numerous cases against the EPA, for example, or the Corps of Engineers, or the USDA, or the Forest Service, or Fish and Wildlife Service, I can assure you that when I represent farmers and ranchers, oil and gas companies, other resource producers, and small businesses, when I walk in the courtroom because of the deference doctrine, typically what you're seeing is that I've already lost the case. And then what I have to do is overtry it because of the deference doctrine. So what the deference doctrine actually does is it places the thumb on the scale of the administrative agency against the citizens of this country, the exact opposite of what is the foundation of America and what is the foundation of our form of government. We don't work for the government works for us. Yet with the deference doctrine, what has happened is these administrative agencies have taken over so much power and authority simply by claiming that a statute or a regulation or even now a guidance document is ambiguous, and therefore they must be the ones to interpret it, and the courts need to stay out of it. This is a good bill. It serves a great purpose of putting the regulatory agencies back in their lane, of only carrying out the law as Congress wrote it, not actually interpreting it as our judicial branch is required to do.